The signature was mine. I had been reviewing post-operative charts for 40 minutes when the name appeared on the intake form. Dr. Renata Sousa-Whitfield, Director of Transplant Medicine at Hargrove University Medical Center, had reviewed 100 names that Tuesday morning. I reviewed them the way I reviewed everything methodically, without ceremony. But this one I read twice. Deanne Calloway. Date of birth, March 4, 1971. That was my sister's birthday. I set the chart down on the nursing station counter. I looked through the glass partition at the woman in bed 7, the one with the IV line already threaded into her left arm, and the untouched cup of ice chips on the tray beside her. She was thinner than I remembered. Her hair had gone gray at the temples. She was looking at the ceiling the way people look at ceilings when they are frightened and trying not to show it. She had not yet seen me. She did not yet know that the physician who held her case file, the one who would determine the next steps in her treatment, the one whose name was printed at the top of her care team roster, was the same woman she had called a failure 11 years ago and blocked from her phone. I set the chart back down. I straightened my coat. I picked up the chart again. The signature was mine. Hello, everyone. Before I go any further, if you have ever been told by someone in your own family that you would never be anything, that you were wasting your time, that you should be grateful for whatever scraps they decided to offer you, leave a comment below. I want to hear your story. Because what I am about to tell you took 11 years to arrive at that moment in Bay 7, and I want you to understand every single step that made it possible. But to understand why that moment meant what it did, I have to take you back. 14 years back. To the kitchen of my grandmother's house in Decatur, Georgia, on a Sunday in October, when I was 28 years old and my sister looked me in the eye and told me exactly what she thought I was worth. I was 28, working double shifts at a pharmacy technician counter in a strip mall off Highway 78, and I had just told my family that I had been accepted to a post-baccalaureate pre-medicine program at Kellerman University in Atlanta. The program cost $18,400 for the year. I did not have $18,400. I had $2,700 in a checking account and a 2004 Civic with a cracked dashboard. I had come to Sunday dinner at my grandmother's house, Grandma Iris, who had been the only person in my life who had ever said the words, "You can do anything," and meant them, because I needed to ask if she might be willing to co-sign a private loan. That was the whole purpose of the visit. I had the paperwork in a folder in my bag. My grandmother was 81 and still sharp. She still made macaroni from scratch. She was in the kitchen when I arrived. My mother, Constance Calloway, was at the table. My sister Diane was already there too, a glass of sweet tea in her hand, and she was in the middle of a story about her new SUV when I walked in. Diane was 34 then, 6 years older than me, married to a man who sold commercial insurance and was very proud of his golf handicap. She had a house in a suburb with a good school district, and she wore that house like a credential. I waited until after dinner. I helped clear the plates. I waited until my grandmother was settled in her chair in the sitting room with her feet up, the way she liked, and then I said I had something to share. I laid out the acceptance letter. I explained the program. I told them about the coursework, the prerequisites, the timeline for medical school applications. I was calm. I had rehearsed it. I used the word plan several times because I thought that would help. Diane put her sweet tea down. "Renata," she said my name the way you might say the name of a wrong turn you've taken on the highway. "You're 28, you want to be a doctor. I want to apply to medical school after do you know how old you'll be when you finish, if you even finish? I've calculated the 38, 40 minimum." She looked at my mother. "Mama, back me up here," my mother said. "It's a lot of years, Renata." "I've already been accepted to the program," I said. "I just need help with the funding for the first year." Diane laughed. Not a cruel laugh, which almost would have been better. It was a dismissive laugh, the kind that says the conversation is not serious enough to require cruelty. "Renata, come on, be real with yourself. You've been a pharmacy tech for 4 years. You barely passed chemistry the first time. This is not a realistic plan." I looked at my grandmother. She was watching me. She didn't speak. She was waiting. I said, "I have a 3.8 in the post-bac coursework I've already completed on my own. I have a letter of support from Dr. Marcus Webb at Kellerman. I have a plan." "You have a fantasy," Diane said, and she picked up her sweet tea again. That was it. The subject, in her view, was closed. My grandmother co-signed the loan. She did it the following Thursday, without telling anyone else. She handed me the paperwork across her kitchen table and she said, "Don't tell me about your grades, just finish." I wrote down the name of the program on a piece of paper that night. I folded it and put it in my wallet. I kept it there for 6 years. What I did not know that Sunday, what none of us knew, was that my grandmother had already spoken to an estate attorney named Gerald Humphrey at the firm of Humphrey, Tate and Briscoe in Decatur. She had been revising her will quietly for 2 years. She had concerns about how her estate would be managed. She had questions about the trust she was establishing, a trust that, as of that Thursday when she co-signed my loan, named me as executor. She had not told anyone. She had her reasons. At the time, I thought her signing the loan was simply an act of love. I did not yet understand that it was also an act of architecture. I drove home that night and I sat in my car in the parking lot of my apartment complex for 22 minutes. I did not cry. I made a list. The list had 7 items on it. Item 1 was the Kellerman Postback program, which I had already started in the evenings. Item 2 was the MCAT, which I had scheduled for the following spring. Items 3 through 7 were the names of medical schools I intended to apply to, ranked by their financial aid packages, and their residency match rates in internal medicine, which was where I had started looking, though that would change. I folded the list and put it in the same pocket of my wallet as the program name. I went upstairs. I set my alarm for 5:15. I went to sleep. The pharmacy counter opened at 7. I was there at 6:58. That is how it started. The first year at Kellerman nearly ended it. Not because the coursework was beyond me, it wasn't, but because the money ran out faster than I had planned. The loan covered tuition, but not the $14 parking permit, not the replacement stethoscope after mine was stolen from a locker in February, not the $340 I had to pay out of pocket when my health insurance coverage lapsed for 6 weeks because I had miscalculated the enrollment period for the state bridge plan. 6 weeks without health insurance coverage, working a pharmacy counter, taking organic chemistry at night. If I had gotten sick during those 6 weeks, the whole plan would have been at risk. I knew it then. I filed the insurance policy paperwork the day coverage resumed, and I kept a copy of it in the same accordion folder where I kept my loan documents and my grandmother's letter. In March of that first year, my MCAT application was flagged for an administrative error, a transcription mistake in my undergraduate science GPA that took 11 weeks to resolve. 11 weeks during which I could not confirm my test date, and during which I sat in a kind of suspended professional dread that I have never fully described to anyone. I called the testing service 4 times. I wrote 2 formal letters. I asked a pre-med advisor at Kellerman named Dr. Obi Nwachukwu to write a letter of inquiry on my behalf, and it was Dr. Nwachukwu who finally got someone on the phone who could fix the error in the system. Dr. Obi Nwachukwu. He was 51 years old, a physician himself who had left clinical practice to run the post-bac advising program after his own complicated journey through academic medicine. He had an office the size of a large closet and a whiteboard covered in residency match statistics that he updated every February. He told me on the day we met that he had advised 214 students over 12 years, and that the ones who made it all had one thing in common. I asked him what it was. They stopped trying to convince people, he said. They just built. I wrote that down too. My MCAT score came back at 516. I did not call Diane, I did not call my mother. I printed the score report, put it in the accordion folder, and went to work at 7 the next morning. I applied to 9 medical schools. I was accepted to 4. I enrolled at Hargrove University School of Medicine in Atlanta in August, 3 years after that Sunday dinner in my grandmother's kitchen. Diane called once during the application cycle, not to ask how it was going, to tell me that my grandmother had fallen and bruised her hip, and that someone needed to help arrange a temporary home health aide. Diane could not do it herself. She was taking the kids to a swim meet in Savannah. I arranged it. I found the aide, a woman named Patricia Goss who came 3 mornings a week, and whom my grandmother liked because she didn't talk too much. I managed the aide's schedule around my own. I did not mention medical school. Diane did not ask. That was the last time Diane and I spoke without conflict for almost 4 years. Medical school is a specific kind of disappearance. You do not vanish dramatically, you simply become increasingly unavailable to the life you had before, and eventually the people in that life stop calling because you are never there to answer. My first 2 years at Hargrove were the years of the basic sciences: anatomy, physiology, biochemistry, pathology. I studied in the library until it closed, and then I studied in my car. I ate dinner at 9 o'clock most nights. I had one friend outside of medicine, a woman named Selena Park who had been my coworker at the pharmacy, and who texted me a meme every Sunday morning without fail, regardless of whether I responded, which I often did not. She was the connective tissue between who I had been and what I was becoming, and I am not sure I ever told her how much those Sunday texts mattered. My family existed at the edge of my awareness the way weather exists when you are deep inside a building. I knew it was there. I knew conditions were changing. Occasionally, a cold front came through, a voicemail from my mother asking when I was going to visit, a second-hand report that Diane had told someone at church that I was off doing something with school, who knows. I did not return most of those voicemails. I was not being cruel. I was being economical. I had exactly enough energy to get through each week. I spent it accordingly. In my third year, I rotated through Hargrove University Hospital's transplant service for 8 weeks, and something shifted. I had done my surgery rotation, and it had been fine, competent, unremarkable. But transplant medicine was different. The complexity of it, the layering of immunology and surgery and long-term patient management, the fact that you were responsible not just for the procedure, but for the arc of a human life that extended years beyond the operating table. I found myself staying late on the transplant floor not because I had to, but because I did not want to leave. My attending that rotation was Dr. Priscilla Fontaine, a hepatobiliary surgeon with a voice like a courtroom and a habit of asking residents what they noticed before she asked them what they thought. She asked me once in the middle of a case review why I had chosen transplant as my concentration. I said, "I haven't chosen it yet." She looked at me over her reading glasses. "Yes, you have," she said. "You just haven't said it out loud." She was right. I said it out loud the following week. I said it to Dr. Nwachukwu in an email I wrote at 2 in the morning. I said I wanted to pursue transplant medicine, and I wanted to know if there was a path. He wrote back within the hour. He was always writing back within the hour, which I never understood and still don't, and he said there was a path and he would help me find it. I matched into a general surgery residency at Hargrove in the spring of my 4th year. 5 years of residency. Then a transplant fellowship at the Callister Institute for Organ Medicine at Emory, which was 2 years. Then a second fellowship in hepatopancreatic surgery that I completed at the Vantnor Medical Center in Charlotte, which was another 18 months. The total from medical school acceptance to the completion of my second fellowship was 12.5 years. During those 12.5 years, I attended 4 family gatherings. One was my grandmother's 85th birthday party, one was a cousin's wedding, 2 were funerals. At my grandmother's 85th birthday, Diane introduced me to her husband's colleague as my sister. She's in school for something medical. I was 2 years into my surgical residency at the time. I was 36 years old. I had already performed 41 independent surgical procedures under supervision and had been named a chief resident candidate for the following year. I smiled at my grandmother's colleague and said it was nice to meet him, and I ate my piece of cake and I drove home. I did not correct her. She had no idea what I had become. None of them did, and I had every intention of keeping it that way. My first official appointment as an attending physician came in September of a year I still think of in terms of what I had sacrificed to reach it rather than what it was on a calendar. I was 41. The offer letter from Hargrove University Medical Center was for a position in the Department of Transplant Medicine and Hepatobiliary Surgery, effective the 1st of October. The title was Assistant Professor of Surgery and Attending Transplant Surgeon. The salary was $347,000 base. I signed the offer letter at my kitchen table at 11:30 on a Wednesday night with a pen I had been given at my residency graduation, and I sat there for a while afterward without moving. I had a glass of water. I looked at the signed page. I thought about the pharmacy counter and the cracked dashboard and the Sunday in October in my grandmother's kitchen, and I thought about the walk to my car that night. I thought about the list with 7 items. I did not call anyone. There was no one in my family to call. There was no one in my family who would have understood what that letter meant in the way it needed to be understood. I called Dr. Nwachukwu instead. He picked up on the second ring despite the fact that it was nearly midnight. "I got the attending position," I said. He said, "I know. Fontaine told me this afternoon. I've been waiting for you to call." I laughed. It was the first time I had laughed in what felt like several weeks. At Hargrove, I built the kind of practice that grows quietly and then suddenly seems large. My first 3 years as an attending, I took every complex case I was offered. I was in the OR more hours than most of my colleagues. I published. I presented at 2 national conferences. I developed a post-transplant monitoring protocol with a colleague named Dr. James Abiodun Carroll, a nephrologist whose office was 2 doors down from mine, and who became the first person at Hargrove who knew my full story, not because I told it to him all at once, but because we had dinner together often enough over 3 years that the story came out in pieces, the way all real stories do. He knew about the pharmacy counter. He knew about Diane. He knew about the loan and the MCAT and Dr. Nwachukwu. He knew because he had asked and I had answered, and he had never once looked at me with anything other than the steady, unsurprised attention of someone who had heard hard things before. "You know it's going to come back around," he said once, over dinner near the hospital. "The family thing. It's been quiet for years. That's not the same as resolved." I knew he was right. I had known it in the abstract for a long time. My grandmother's estate had never been fully settled. There were questions about the trust distribution that had been deferred repeatedly, for reasons that had to do with Diane's challenges, contesting the executor designation, and Gerald Humphrey's careful patience in responding. I had spoken to Humphrey twice in the past year. He had used the phrase, pending resolution, both times, with the particular stillness of a man who had been in estate law for 30 years, and had learned not to predict timelines. I had documents. I had trust documents and medical records and correspondence going back years, organized in a system I had developed during residency when I realized that the ability to manage paper was as important in medicine as the ability to manage patients. I had a copy of my grandmother's will. I had a copy of the executor designation. I had a copy of the letter my grandmother had written by hand, in her careful cursive, explaining her reasoning, a letter that Gerald Humphrey had witnessed and notarized and retained in his files at Humphrey, Tate and Briscoe on Commerce Drive in Decatur. What I did not have, what no one had yet, was the conversation that was coming. I was rounding on a Tuesday morning in late autumn, 4 years into my attending position, when my scheduler flagged an intake form from the previous evening's emergency admissions. The patient had come in through the ER with elevated bilirubin and right upper quadrant pain, possible cholangitis, rule out biliary obstruction. The admitting team had requested a transplant medicine consult, standard process. I pulled the chart. The name was Diane Calloway. I looked at it for a long moment. I looked through the partition at the woman in bed 7. I thought about James Abiodun Carroll saying it's going to come back around. I thought about Gerald Humphrey saying pending resolution. I thought about a Sunday in October and a glass of sweet tea and a laugh that said the conversation was not serious enough for cruelty. Then I thought about the trust, the $2.3 million estate, the distribution that was still unsigned, the signature that was mine. I picked up the chart. I straightened my coat. I had come that close to everything surfacing before it was time, but it wasn't time yet. I walked toward Bay 7. The door to Bay 7 opened on a standard hospital hinge with a standard hospital sound, and Diane looked up from the ceiling she had been studying and saw me, and for 2 full seconds her face did nothing at all. Then recognition arrived, and with it something I had not seen on my sister's face in many years, uncertainty. "Renata. Good morning." I moved to the foot of the bed and opened the chart the way I opened every chart, with my full attention on it rather than on the person in the bed. "Dr. Sousa-Whitfield, I've been asked to consult on your case by the admitting team." She stared at me. "Your labs from last night show elevated bilirubin," I said. 13.4. "Your ultrasound indicates biliary dilation that we need to investigate further. I'm ordering an MRCP this morning. Do you have any allergies I should note?" "Renata." She said my name again, differently this time. As a question or as a correction, I wasn't sure which. "Do you have any allergies?" "No." "No allergies." She pushed herself up slightly against the pillow. Her IV line caught on the bed rail and she freed it with a practiced motion. "You work here." "I'm the director of transplant medicine." She looked at me for a long time. I looked at the chart. The admitting notes were thorough. The overnight resident had done good work. The differential was appropriate. I made 2 additions in the margin and initialed them. "I didn't know," she said. "There's no reason you would have." I closed the chart and looked at her for the first time fully, the way I look at patients when I want them to understand they have my complete attention. "How long have you had pain in the right upper quadrant?" She answered the question. She answered it with dates and a description of the pain's character, and the name of the gastroenterologist she had seen twice in the preceding months without resolution, a Dr. Philip Gaines at a clinic in Decatur, whose notes I would request later that morning through the medical records department for continuity of care. She answered it the way patients answer clinical questions when they are frightened enough to be honest. I listened. I took notes. I was, in that room, nothing other than her physician. That was the only role I intended to play in Bay 7. When I left, I told her the imaging team would contact her within the hour. I told her someone from my team would check in before noon. I told her she could ask any of the nursing staff if she had questions about the process. She said, "Renata." "Wait," I turned at the door. "The trust," she said. "Gerald Humphrey called me last month. He said there's a distribution pending. He said you have to sign." I looked at her. "I know you're busy," she said. "I know you have a hole. I can see that you have a hole." She stopped. She looked at her hands. "My medical bills are significant. I've been dealing with this for 8 months and the insurance covered less than I expected and I have a payment plan but the bills are." She stopped again. "I need the distribution, Renata." I thought about Gerald Humphrey's office on Commerce Drive and the 2 conversations I had already had with him about the pending distribution, and the letter my grandmother had written in her careful cursive that I had read more than once in the past year. I thought about the $2.3 million figure that had been cited in the estate documents, and I thought about the trust structure my grandmother had designed with a specificity that had surprised even Humphrey when she first explained it to him. I thought about all of this in the time it took me to say, "I'll be in touch with Mr. Humphrey." Then I left. I called Gerald Humphrey that evening. I signed the first document. There was no going back. What Humphrey had been managing with his particular patients for the past 3 years was not simply a trust distribution. It was a trust structure that my grandmother had built with considerable foresight, and that Diane had spent 2 of those 3 years attempting to challenge on the grounds that the executor designation was improper, that my grandmother had been unduly influenced, that the documents had been prepared under duress, that the timeline of the estate planning overlapped too conveniently with the co-signing of my loan. These were claims that Humphrey had answered systematically and in writing, with documentation, every time they were raised. The will had been prepared over 18 months. My grandmother had met with Humphrey 5 times across that period. She had been evaluated twice by her physician of record, Dr. Anita Rosario at Decatur Internal Medicine, who had documented her cognitive status as intact in both evaluations. The medical records from those evaluations were in Humphrey's file. The contest had gone nowhere because it had nothing to stand on, but it had delayed the distribution, and during the delay Diane's financial situation had shifted in ways I understood only in outline from Humphrey's careful summaries. What I gathered in the 2 weeks after Diane's admission was the full picture. I called Humphrey the evening I left Bay 7, and I told him I was ready to move. He said he had been ready for some time. He said there were 3 documents that needed my signature and 1 that needed a notary, and that he could have everything prepared within the week. I told him to proceed. He said he would also need me to confirm my availability for a probate review that had been scheduled, almost ironically, for the following month at the Fulton County Probate Court on Washington Street. A routine matter, he said, but my presence as executor was required. I confirmed. He said he would send the documents by courier. The day after the Humphrey call, James Abiodun Carroll came by my office at the end of the afternoon and sat in the chair across from my desk without being asked, which was a habit of his that I had stopped finding presumptuous about 18 months into our friendship. "How are you doing with the Diane situation?" he said. "She's responding to treatment. The imaging confirmed a common bile duct stone. Dr. Park is handling the procedure Thursday." I meant the other situation. I looked at the stack of folders on the corner of my desk. The top one had a label I had written myself, Estate Humphrey Fulton Co. "I called the attorney last night," I said, "and we're moving, probate review next month." He looked at the folder. "She's going to find out you're the executor before that, isn't she?" "She already knows I'm the executor. She's known for 3 years, she just didn't know I was her physician." "She didn't know the 2 things were going to be in the same room." "No," I said, "she didn't." He was quiet for a moment. "What do you need?" "I need you to tell me if I'm thinking about this correctly." I leaned back in my chair. "She is my patient. The clinical decisions are completely separate from the estate. I am not using her medical information in any trust capacity, and I am not allowing the estate situation to affect her care in any direction. Agreed. The ethical question is whether I should have transferred her case when I recognized her name. Should you have? Probably yes, if my judgment were impaired. I don't believe my judgment is impaired. Do you want me to be an outside reviewer on her case? Formally, I had thought about this already. Yes, I said, I'd like that documented. He nodded. He took out his phone and sent himself a note. That was James, precise and immediate. He did not write things down to feel organized. He wrote things down because he intended to do them. Done, he said. I'll do a formal chart review by Friday. If anything looks like a clinical decision that could be read as influenced, we flag it together. Thank you. You've been doing this right, he said. You know that. I did know it. I had known it from the moment I turned at the door of Bay 7 and saw Diane's face processing the gap between who she thought I was and who was standing in front of her. The gap had always been there. She had simply never been in a room where it was visible. The documents from Humphrey arrived on a Thursday by courier, in a sealed envelope with the firm's return address. I signed 3 of them at my desk. The 4th required a notary. I walked 2 floors down to the hospital's administrative wing and had it notarized by the office manager, a woman named Corinne Westthal who had been at Hargrove for 22 years and who notarized documents with the same unhurried competence she brought to everything. She stamped the page, signed it, handed it back, and returned to her screen. I thanked her and went back to my office. I called Selina Park that night. Not about the estate. About her mother, who had been having joint pain and whose primary care physician had referred her for a specialist appointment that had been difficult to schedule. I had the name of a rheumatologist I trusted, and I gave Selina the name and the direct line to the scheduling desk. We talked for an hour. She asked me how I was doing, and I told her I was managing something complicated, and she said she knew that voice and that I should call her when it was done. I said I would. That was the moment I understood exactly how much they had underestimated me. 2 days before the probate review, Diane called my cell phone. I did not know she still had the number. I had changed it twice since she had blocked me, but I had given the current number to the hospital's social worker, assigned to her discharge planning, and apparently the information had traveled. I answered because I always answer numbers I don't recognize. I want to talk about the distribution before the court date, she said. I'd like to resolve this I'd like it to be simpler than a formal hearing. What would simpler look like to you? I said. I think we should sit down. The 3 of us, you, me, and Mama. Gerald can be there if you want, but I think we can agree on something reasonable without making it a legal proceeding. I was in my office. The estate folder was in the second drawer of my desk. The signed documents were with Humphrey's office. The probate date was in my calendar. I looked at my window, which faced west and was showing a late afternoon sky in the specific orange of November, and I thought about the word reasonable and who in this conversation had been reasonable across 14 years and who had not. I'll be at the probate review on the 22nd, I said. Gerald will be there. If you'd like to reach an agreement before that date, you can contact Gerald's office. She was quiet for a moment. You're not going to make this easy, are you? I'm going to follow the process that Grandma Iris set up, I said. That's what an executor does. She said, Renata, I'll see you on the 22nd, Diane. I ended the call. I held the phone for a moment. Then I put it face down on the desk and went back to the paper I had been reviewing before she called, a research update on post-transplant immunosuppression protocols that I was co-authoring with 2 colleagues from the Callister Institute, and I finished reading it and made my notes and sent my edits by 7:30 and went home. She thought she had won the phone call. She had 2 more days. The Fulton County Probate Court on Washington Street has a particular quality of light in the morning, fluorescent and without warmth, the kind that makes everyone look slightly underprepared regardless of how prepared they actually are. I arrived at 8:52 for a 9 o'clock hearing. I wore my gray suit. I carried the leather document case I had bought with the first bonus I received as an attending physician, which I had done deliberately, and which I thought about each time I carried it. Humphrey was already there, at the counsel table to the right, arranging papers with the unhurried precision of a man who had been in probate court many times and had never once been surprised by what happened. He was 63, with silver hair and the reading glasses he wore on a chain around his neck, and when he saw me he stood and shook my hand. Everything is in order, he said. All 4 documents are filed. The trust documents are logged with the court. The financial disclosure has been submitted. Diane, she retained an attorney, man named Cutter. Stephen Cutter from Baxter and Cutter on Peachtree. He's capable, he'll raise the undue influence argument again. And you'll answer it again. With slightly more finality this time. He indicated the chairs. Shall we? I sat. I placed the document case on the table. I looked at the door. Diane arrived at 8:58 with my mother and a man I did not know who was carrying a briefcase and who I understood from context to be Stephen Cutter. Diane had dressed carefully. She wore a dark blazer and her hair was pulled back, and she had the slightly overprepared look of someone who has decided that appearance is a form of argument. She saw me at the table. She saw Humphrey. She sat down at the opposite table without making eye contact. My mother, Constance, sat beside her and looked at me with an expression I had seen on her face at the Sunday dinner in October 14 years ago, worried that something uncomfortable was about to happen and uncertain which side she was on. Cutter leaned over and said something to Diane in a low voice. She nodded. The probate judge was a woman named the Honorable Marian Osei, who entered at 9:03 and arranged her materials with practiced efficiency and acknowledged both counsel with a nod. There were 8 other people in the room, 2 of Humphrey's staff, a court reporter, a clerk, and 4 people from the public gallery whom I did not know and who were there for a different matter. 14 people, counting the judge, the 2 attorneys, Diane, my mother, and me. More than enough. Judge Osei reviewed the filing summary and asked Humphrey to confirm the documents on record. He listed them: the will, dated and executed with 2 witnesses and a notary. The trust instrument, establishing the Iris Me Calloway Family Trust, dated 3 years before my grandmother's death. The executor designation, naming me, Renata Sousa Whitfield, as sole executor of the estate, with a specific provision explaining my grandmother's rationale, a provision that Humphrey now asked permission to read into the record. Judge Osei granted it. Humphrey read it. The provision stated, in my grandmother's language as transcribed and witnessed by Humphrey and his associate, that she was designating Renata as executor not out of favoritism, but out of confidence, specifically, confidence in Renata's professional judgment, her organizational capacity, and her demonstrated commitment to managing complex responsibilities under pressure. She had watched Renata, the provision said. She had watched her work. She had watched her build something from nothing with steadiness and without complaint. She trusted her. She wanted the record to say so. Diane's hands, which had been resting on the table, went still. That was the first document. I had 3 more. Cutter rose and offered his counterargument. It was competent. He raised the undue influence question and cited the timing of the loan co-signature relative to the estate planning timeline. He cited the fact that Renata had limited contact with the family during the period in which the trust was established, which he framed as evidence that the designation was made without full family consultation. He was measured and professional, and he made the argument as well as the argument could be made. Humphrey responded. He submitted the documentation from Dr. Anita Rosario, 2 separate evaluations of my grandmother's cognitive status, 18 months apart, both documenting full capacity. He submitted the correspondence record showing that my grandmother had initiated the estate planning process before the loan co-signature, not after. He submitted the meeting logs from Humphrey's own office, showing 5 separate consultations across the 18-month drafting period, each one initiated by my grandmother, each one conducted without my presence or knowledge. He submitted a letter from a second attorney who had reviewed the trust instrument at my grandmother's request specifically to confirm that it was sound and that she understood its implications. Judge Osei reviewed the submission without expression. She asked Cutter if he had documentation to support the undue influence claim beyond the timeline argument. He said he did not. She asked if there was any evidence that the testator lacked capacity at the time of signing. He said the evidence was circumstantial. She looked at him over her reading glasses for a moment. Then she turned to me. Dr. Sousa Whitfield, she said, as executor, you have the signed distribution documents ready for review. Yes, Your Honor. I opened the document case. I removed the 4 signed and notarized pages and passed them to Humphrey, who passed them to the clerk. And you are prepared to execute the trust distribution as specified? Yes, Your Honor. She reviewed the documents. She reviewed them thoroughly, which took 11 minutes, during which the room was very quiet. Diane's attorney leaned over and whispered something to her. She shook her head slightly. My mother was looking at her hands. Judge Osei looked up. The court finds the trust instrument valid and the executor designation proper, she said. The contest on grounds of undue influence is denied. The documentation submitted is consistent with a testator of full capacity acting independently across an extended planning period. She looked at both tables. The Iris Me Callaway Family Trust distribution will proceed as specified in the trust instrument. Executor's authority is confirmed. Distribution of the estate assets, totaling $2,340,000, will be released according to the trust's terms. The executor is authorized to sign all remaining documents effective today. She set the documents down. Mr. Cutter, she said, is there anything further from your client? Cutter said, no, Your Honor. Diane said nothing. Her voice had not changed because she had not spoken. But she had gone a specific kind of still, not the stillness of composure but the stillness of someone who has just understood the full shape of something they had been looking at sideways for years. My mother reached over and put her hand on Diane's arm. Diane did not move. Judge Osei closed the matter. She collected her files. She left the bench. Humphrey gathered his papers with the same unhurried efficiency he had shown arriving. He had done this before, he would do it again. He leaned over and said, in the conversational tone he used for everything, the distribution can be processed within 30 days. Standard timeline. Thank you, Gerald, I said. I closed the document case. I looked across the room. Diane was speaking in a low voice to Cutter. My mother had turned slightly toward me and then looked away. The court reporter was closing her equipment. The clerk was filing. Cutter approached Humphrey with a follow-up question about the distribution timeline. They spoke. I stood. Then Diane looked at me. Directly across the room, in the fluorescent light that makes everyone look underprepared, she had the expression of someone doing a recalculation they had not expected to need to do. It was not defeat, exactly. It was more like the specific expression of someone who has spent years estimating a distance and has now arrived at it and discovered the estimate was wrong. I looked at her for a moment. Then I picked up my document case and walked to the door. There is not a dramatic version of what came after. That's the part that surprises people when I tell this story. They expect a confrontation in the hallway, a final exchange, a moment that closes like a scene in a film. What actually happened is that Diane called Humphrey's office the following week and asked about the trust terms, specifically, about what the distribution included, how it was structured, and what obligations came with it. Humphrey explained. She listened. She did not contest further. The distribution was processed 31 days after the probate hearing. The trust instrument had specified its own terms, which my grandmother had written with what I can only describe as characteristic precision. The estate was distributed in 3 portions, 1/3 to me, 1/3 to Diane, and 1/3 placed in a restricted charitable trust designated for medical education scholarships at historically Black colleges and universities, a designation my grandmother had added in the final revision of the trust, 9 months before she died. Gerald Humphrey had not mentioned that particular detail to anyone in advance. It appeared in the final distribution summary as a fact, without drama, the way my grandmother had done most things. Diane received approximately $765,000. The sum covered her medical bills, the unpaid balance on her home, and left a remainder that her financial advisor, a woman she had retained the previous year and whose services I knew about only through Humphrey, would manage according to whatever plan they had developed. I do not know the specifics, and I did not ask. I received the same amount. I put the majority of it into a fund I had been building for 5 years for the purpose of endowing a post-baccalaureate scholarship at Kellerman University, specifically for working adults seeking careers in medicine who needed bridge funding for their first year. The scholarship is named for Iris Me Callaway. The first recipient was selected the following spring, a 27-year-old pharmacy technician from Cobb County named David Osei, no relation to the judge, who wanted to be a physician. He is currently in his 2nd year of medical school at Morehouse College of Medicine. I am still at Hargrove. I was named Director of Transplant Medicine 4 years ago, and I have held that role since. My department has 12 attending physicians and a residency training program that I helped rebuild from a 4-resident track to a 7-resident track over 3 years. I have published 31 papers. I have a home that I own and a garden that I am slowly learning not to kill, and I have dinner with James Abiodun Carroll and his family approximately once a month, and I call Selena Park on Sundays, usually without a specific reason. Diane and I are not close. I want to be honest about that. The distribution did not repair what had broken, and I did not expect it to. We speak 2 or 3 times a year, usually about practical matters, a cousin's event, a question about our mother's care as she ages. The conversations are civil. They are not warm. I am not certain they will ever be warm, and I have reached a state of genuine acceptance about that, which took longer to achieve than the legal resolution did. What I think about when I think about Diane is not the Sunday dinner in October, or the word failure, or the laugh that said the conversation wasn't serious enough for cruelty. What I think about is my grandmother at 81 at her kitchen table, signing a co-signature form for an $18,400 loan for a daughter who was 28 and had $2,700 and a plan. My grandmother understood something that neither Diane nor I fully understood at the time, that the architecture of a life is built in private, over years, and that the people who dismiss it while it is being built rarely recognize it when it is finished, and that this is not your problem. It is simply a fact about how building works. I did not set out to prove anything to Diane. I want to be clear about that. I set out to become a physician because I believed I could, and because Dr. Nwachukwu told me to stop trying to convince people and build instead, and because my grandmother looked at me across her kitchen table and signed her name without asking me to justify myself first. The collision with Diane was a consequence of geometry. We were moving in directions that were always going to intersect. I could not have stopped it. I chose to be prepared when it arrived. At the probate hearing, Diane was not my enemy. She was a person who had made estimates and whose estimates had been wrong. I have made wrong estimates. Everyone has. The difference between us, in that moment in the fluorescent light, was not that I was righteous and she was not. The difference was documentation. The difference was preparation. The difference was the 12.5 years I had spent building something that did not require anyone's permission to be real. And if there's anything this experience taught me, it's this. 1. What you build in silence cannot be argued with. The people who dismissed you will eventually have to walk through the door of what you have made, and no amount of certainty about who you were will protect them from who you have become. 2. Documentation is not a weapon. It is a record of your own seriousness, and every time you sign your name to something true and file it in the right place, you are writing the answer to an argument that hasn't happened yet. 3. Your family's story about who you are is not your autobiography. It is their autobiography, and you are under no obligation to live inside it. Was I wrong to say nothing to my family for 14 years, to let them believe I was failing while I was building the thing that would eventually require them to sit across a table from me and accept what I had become? Tell me in the comments. If this story gave you strength, hit that like button. It means more than you know.